We are here with Advocate Matthews Nedambara. Sir, in your previous video, Never Trust a Judge, you had a lot of very strong opinions, but I still felt that you hadn't said everything that you wanted to say. So I'm going to call this Never Trust a Judge Part 2, and please continue with your deliberations.
Never trust a judge. True, I only spoke about the theoretical aspect. The practical aspect, to say something more, I am somebody who is very fearful. Fearful. Many people call me as a very brave man. That is not the truth. See, today we are the largest democracy. Our constitution guarantees the freedom of speech and expression. But when it comes to the institution judiciary, there is no freedom of speech. And the founding fathers, for reasons which I find difficult to fathom, that these fundamental freedoms are subject to contempt of court. The Constitution itself says that this freedom of speech is subject to other consideration like contempt of court, security of state, etc. So, contempt of court is a unwieldy jurisdiction. There is no law. Even if the parliament were to make a law defining the concept of contempt, the parliament did, and the Contempt of Courts Act was enacted. But still, the whole problem is when it comes to contempt of courts, the judge and the prosecutor is one and the same. Contempt of Court Act is against the basic jurisprudence. It all originated from the Dark Ages. So, I always emphasize on the classical Roman law. That is prior to BC 200 to 3rd century. That is the time. That is the time of wisdom, classical Roman. Then after that, the Holy Roman Empire, the clergy rule, and the contempt of court is all that originates from that. It belongs to the Dark Ages. So anything which any comment you make about the church is considered to be heresy and was subjected to capital punishment. So in the same system in 21st century we are following. So if I say something, the court can take suo motu contempt proceedings against me, and the only way for me to escape the wrath of the court is to offer apology. So that is one aspect of it. Now the question is, in a short video, it is a subject which is very difficult to be stated. But I can say, not now, when I was a young lawyer, so there was a very learned judge in Kerala High Court. He was a very learned judge, but he was very partial. So in a particular kind of jurisdiction cases are listed before a particular kind of judge, particular service matters, motor vehicles matters. So that case alone comes. And most of these cases, the cases which come up are of the same nature. So this judge is known to favor one lawyer and disfavor the other, discriminate the other. So one lawyer, I don't name him, he had two cases. So one he is fired through his lawyer who is a favorite of the judge, and the other party he himself appeared. So in the first case the judge granted stay, and when it came his turn, the case was they went on to dismiss it. Then the lawyer said, "My lords, the case serial number dash, it was my case. I only engaged say so and so." So the tragedy here on the same set of facts, on identical situation. Though the fundamental principle of law is that in similar cases, similar ought to be the remedy, in reality it is not. It is all, there is nothing like law. There is no law. It is what the lawyers and judges do in the name of law. Otherwise, it's all about a judge decides something. If a judge is pleased with me, if just likes my face, that's what we call face value jurisprudence. Likes the face, then it decided to decide in your favor, then he find reason to that. So first you come to a conclusion, then give reasons. That is unfortunate. And there is no mechanism to regulate it. And what I think is, at least the bare minimum is that a right to point out these great malaise. And the people and the lawyers should have the freedom to criticize. Today the lawyers never dare, because your next case, all discretionary jurisdiction, 226, Article 32, 136, all discretion. And think of most of the cases where discretionary jurisdiction exercise, not even a judgment is returned. SLP is dismissed, writ petition is dismissed. No reasons are offered. So the judges, the lawyers, say, out of consideration for their existence, out of fear, never dare to criticize. So I plead guilty of being fearful of the inviting the wrath of the judges. I don't dare to speak much.